Welcome to Rebel Chaser. My name is Gail, and I've got several videos for you tonight. I've got one from Judge Middleton, and then one from Judge McNally, one or two. I think there might be two from Judge McNally. And then one from Judge Meyer. He's got the neighbor from hell. And then Judge West had a day of reprimands. She had a lot to give out today, so you get to watch those. And then Judge Bryant even had a reprimand to give, so you get to watch that. And then the last one is Judge Chisholm. You know, got to round out the end with traffic one for you. Anyway, I'll let you guys watch.
We had the record just running, but we're back addressing the matter of Tina Kaufman. The file number is 241968. Ms. Kaufman is here with Mr. Stickley, the Chief Public Defender. Autumn Kiefer is here. Mr. Stickley, here's what I understand. The defendant was here today for a probation review with her probation officer, Autumn Kiefer. Autumn smelled alcohol, gave the defendant a breath test, and the result was .087.
Correct, at 9:40 a.m.
And she drove here. So it is a condition of her probation that, I'll just read it the way it's in the order. It's an old order. She was sentenced to 93 days, credit 2, 91 days to serve, and I deferred a few. So she has 88 jail days hanging over her head. It is a condition of her probation that she take a test upon demand of any police or probation officer. Refusing a test, missing a test, or a positive test will cause an immediate 1-day jail term and whether potential probation violation consequence. So the defendant got arrested on May 26th, which resulted in this conviction, May 26th of 24. She was in a crash and her blood alcohol was .294. She got arrested again on August 7th for drunk driving and file number 241471 SD. Her blood alcohol at that time was .244. She was on bond on the earlier case when she got arrested on the second case. Prosecutor dismissed the second case. It was a freebie, and she was placed on probation on this case under the theory that she would be a great sobriety court candidate. However, she moved to Indiana, and we were unable to place her in our sobriety court program because she resides in Indiana. She was placed on a traditional probation. She got arrested for drunk driving again on June 19th in LaGrange County, Indiana, has an arraignment in LaGrange County, Indiana on June 30th. So she is a danger to the public. I don't know what her blood alcohol was. She has a terrible alcohol substance abuse disorder, and she continues to drive. And this is dangerous. Plus, she's legally intoxicated right now, so I can't really even do anything. So I'm going to find a contempt and probation violation. And it's going to be taken into custody, and we'll address this tomorrow when she's sober. Further. Let's see what time we got tomorrow. Can't really do anything when the person's legally drunk to try to make a record or talk about things. We need to wait till you're sober. About 9 o'clock tomorrow. I'll give you an order violation of probation. I don't want to make sure she doesn't get out before tomorrow. Or 2 days jail, credit 0. 2 days to serve. Further hearing 6/25/25 at 9 a.m. Ms. Kaufman, do you have pets?
I do.
What do you have?
I have 2 little Pomeranians.
You might want to find somebody to take care of your animals. All right, you're going to jail. I'll see you tomorrow morning at 9 a.m. when you're not at .08, and we'll talk further about this.
Your Honor, I'm sure there's protocols at the jail, but just to put everybody on alert, I am concerned about the possibility of some withdrawal issues in the next 24 hours. So if that can be noted or something, make sure that we keep an eye out for.
All right, we'll do that. Michelle's in agreement. Also, you're going to be referred for a new criminal investigation for driving to court while intoxicated. You also were a daily user. I don't know if you got in your system as well or not. But we can't keep going this way. You're going to kill somebody or yourself or both. So I'll talk with you tomorrow. All right. Thank you, Mr. Stickler.
That's it. Amanda Emerson. Is she here, Ms. Emerson?
She's in Brownstown, Judge.
Amanda Christine Emerson. 24B146354, 24B146879, 25B147836. Tell them somebody called them. Tell me somebody called them. All right, good.
They're on there.
Your name, ma'am?
Amanda Emerson.
Appearance?
Good afternoon, Judge. I'm here on behalf of Ms. Emerson.
David Floyd Carter, I'm addressing Township now.
She didn't show up June 2nd, right? It's what happened?
June,
That she appeared intoxicated, Your Honor.
in the court.
Why was she taken into custody?
She, yesterday, she was charged with trespassing at Tella Valley and assault and battery. She was arraigned down the hall.
The judge has, those cases have been set for trial.
Did you guys pre-try these?
There's no offer on, there was an offer prior. Ms. Emerson failed to appear on the 11th last week. So the prosecutor is not willing to offer anything.
Well, didn't we have a bench trial scheduled June 2nd?
We did, there was we anticipated a resolution, Judge, but that was the time that she came in. She was intoxicated, that was the time she blew a .17. So we set these out.
We're scheduled for final pretrial down the hall on the 25th.
I'm not adjourning this thing again.
I can respect that, Your Honor.
I mean, what is wrong with you, Ms. Emerson? What is wrong with you? I begged you to get into sobriety court 3-4 years ago. Begged you.
I have a day.
I don't want to hear it. Please don't say nothing.
Okay.
Please. I mean, these cases been going on. I don't even know what to do with her anymore. I'm throwing up my hands. I'm at wit's end. I really am. Other than just lock her up, set a bond she can't make. So remind me, she came in here June 2nd.
We were set for trial on that day, Judge.
Lisa.
Judge, I have a note on June 2nd that she was in the hospital, and that's how we adjourned to today.
Oh, that was the urgent care date then. So the one prior to that, she was intoxicated. Then June 2nd, her dad appeared with an urgent care letter.
Okay, right, I apologize, and yes,
Was she in front of Judge Hudson today too?
She was, Your Honor.
What happened over there?
It's been set for a jury trial, all matters, and she was given a $4,000 bond collectively.
When's the jury trial set for?
The jury trial is scheduled July 18th.
July 18th.
For the final pre-trial on June 25th.
When she was picked up, was she, do you know, Detective?
I'm not aware, Your Honor. I don't believe so. I think she was on her way to the liquor store.
I don't know whether to be, you know, I feel for you. You're ruining your life. You are the whopping old age of 36 years old and you are ruining your life. You're not going to make 40. You're not going to make it to 40. I don't want to sound mean, weird, rude, anything else. I just don't know what to do with you anymore. There's nothing for me to do anymore. I'll do the same thing. I'll set a fire on a pretrial June 25th. Let's see, Lisa, let me think. Yeah, I guess I can do that in the morning, but I'd like her to come in here early. I mean, if you guys get a global resolution, fine, but I'd like to have her in here at 10, not at 2. You know what I mean? I'm not blaming anybody.
On what day, Judge?
On the 25th. She might still be in
I was gonna say,
custody.
Judge, I don't know that she can make the $4,000 bond, so she may still be in custody.
I know. I'm gonna need a jury trial date too, Lisa. These are all. So I'll set a final pretrial the 25th in the morning at 8:30. Is she gonna be, she's not gonna stay in Brownstown though. You guys are not gonna keep her there. You're taking her downtown, right?
Correct, Your Honor. She has a felony one with Wayne County as well.
She has a felony in Wayne County as well?
Yes.
I mean, I'm wondering if she doesn't have bigger fish to fry, if you know what I mean.
I wasn't aware of that.
I'm just saying, she's got another trespass, but I could care. June 25th at 8:30. Let's go about that. We'll figure out a jury trial date. You're not gonna be happy till you end up with the Department of Corrections. I can just tell. You can't wait to get there. I mean, you're doing your best. You cannot wait to get to the Department of Corrections. And if you think any other place that you've been has been surprising, that was like going to Hawaii. So keep it up. I mean, you're getting there. Give me a jury trial date, Lisa.
July 25th at 8:30.
July 25th at 8:30 will be the jury. I'm not going to adjourn it. I don't care what happens anymore. We're going to have her here. July 18th. Will you write all these dates down? I don't even know what
I'll take care of
I don't even know what to do. 5,000, 10% on her, on all of these files. 5,000, 10%. You can't go back. Did somebody not just tell me it was trespassing? Was it over at the same location area?
Yes, Your Honor, she has
Shocking.
2 new cases.
Shocking. She's got 6 cases there. You can't enter Hickory Lane in Brownstown, no contact with Julie Fisher or prosecution witnesses. You cannot go back to Dennis in Brownstown, no contact with prosecution witnesses. You cannot go back to, I guess that might cover them. You cannot leave the state, cannot violate a law. You must appear in court as directed. You're going to have to post $1,500 to secure your release on your release on those 3 cases. I don't know what else to tell you. Thank you. Have a good day. Good luck. People against Kayla Linfeld, 25B82688C.
There's one more.
Is this Judge Hessen's or is this Judge mine?
Both. I think there's 1, 2 in Judge
There's two at Judge Hassan, one is a dismissal, one is an adjournment, and the other one is yours, and will be an adjournment, Your Honor.
I have 25B82383C, 25B82688B and C, and I have 25B148713. So what are we doing here?
So we are adjourning.
Well, first of all, she's never been arraigned on the June 2nd cases.
Stands mute, Your Honor, and we are bringing up the information.
These are Judge Hessen's, right?
Yes, Judge.
So I'm entering a not guilty plea on those. Your name, Ms. Felton?
Caleb Felton. An attorney for you on behalf of Ms. Felton.
And then I've got another one from June 2nd, vicious act. She stands mute, waives formal reading.
Yes, Your Honor.
And then I've got another one from May 26th. It's mine.
And that's being adjourned.
Well, first of all, she stands mute, waives formal reading on that.
Yes, Judge.
So what are you doing on these cases? Adjourn for discovery on Judge Hessen's. And you're nolly processing the dog at large case.
Correct, Your Honor, that was a duplicate ticket.
I see. What's it a duplicate of?
Of the June 2nd incident.
Whose brownstone docket was this? Mine or?
Yours, for your matter.
So they did an
Okay.
emergency one, Your Honor.
Wait a minute. I wouldn't say a word right now. I read her brief. You're gonna have a comeuppance with me.
Okay.
You think you're gonna violate orders in this court from these judges, me or Judge Hessen, like you
No.
just did?
No, I was saying,
I don't want you to say a word.
okay.
She tells you to do something and you take the dog and take it to Tennessee allegedly, or at least that's what you tell the police. Don't start with me. Don't say a word. You should not have said a word. And then you're acting back here, you're laughing, you got your kid fooling around. This is a big game to you, huh?
He's autistic.
I'm sorry about that. I really am. But you're still back there laughing with your friend. I'm telling you, you obviously don't think this is important or serious at all.
I laughed through pain, to be honest. Instead of crying.
I mean, I am really sorry about your son. I did not know that, and all right. Give me a second here. PR. All right. I'm just kind of confused, to be honest. I guess when I read the brief, I must have misunderstood something. I got an A, B, and C of 688. We're adjourning all of those, right?
Correct, the two vicious animal cases. Yeah.
Those are in front of Judge Hess, right? And then I've got 25B82383 A, B, and C that are in front of me. And you want me to dismiss which one?
The singular citation with dog at large. It was a standalone case.
Two 25B148713.
Hope so.
Okay, so I'm gonna go ahead and dismiss that one. That one is dismissed.
Thank you, Your Honor.
Now, where is the dog now?
It is in animal control custody. Ms. Felton did turn over the animal on Sunday night.
but I want to go over this brief with you.
Yes, Your Honor.
So the Judge Hessen ordered her to turn over the animal to Brownstown Animal Control to be held at, this is after the June 2nd dog, right?
It was.
And she ordered her to turn it over to the animal control to be held at the owner's expense until the hearing is held. And you're saying defendant failed to do so. And then that was the second act. And these were bad of young children, right?
You were, yeah. The first incident was the second one was bruising around a child's neck.
And then she advised animal control she drove the dog to Tennessee and gave the dog to someone she contacted over Facebook. But then she recanted on that and brought the dog in, right?
She did, Your Honor.
All right, so tell me exactly what you would like me to order in terms of bond. That the dog remain at the Brownstown Animal Shelter until further order of the court?
Yes, Your Honor.
Do I have a bond sheet here? Yes, I do. Do you have just one dog, ma'am?
I have two,
Where's the other one?
my house.
This first dog, can you describe the dog for me, Miss?
Animal control on that, can Your Honor, she's here.
Good afternoon, Your Honor.
Your name?
Kaylin Armstrong.
Okay, just let me make a note here. And Lisa, I'm just gonna write this one, and then I'm gonna ask you to fill this out. Go ahead. So what kind of a dog is that one?
It's a Siberian Husky Pit Mix. Black
Si-
and white
Siberian Husky
Pit Mix.
Pit Mix.
Correct.
Defendant's dog to remain in Brownstone Animal Shelter until further order of the court. Ma'am, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You're not to have any contact with any of the victims. You cannot write, phone, see, text, email, or communicate with them, or have anybody else do any of those things for you or on your behalf. That will be the bond conditions on all of these. And again, the dogs to remain at the Brownstown Animal Shelter, that's Siberian Husky Pit Mix, until further order of the court. We'll give you new dates on these. And Lisa, do you want to give me the dates? And I'm going to have you write all this down. I got to get moving on these other cases. So what date?
July 16th at 10.
This will be July 15th at 10.
16th.
16th at 10. All right. Do you understand everything, ma'am?
Yes.
So I'm giving you a personal bond. I have to tell you, when I read these briefs, I wondered if that was appropriate. You cannot ignore orders of the court. Do you understand that?
I guess.
All right, let's let it go. You fill out a petition for court-appointed lawyer going forward. That will be the date. Lisa, just make sure you write that on all these so Judge Hessen knows what I did. Will you please?
Okay, hers are getting adjourned at the same day.
Yeah, we can do
Okay.
it the same day unless she's not here or whatever.
Okay.
Okay, thanks.
Okay, so what's gonna happen here is I'm gonna swear in, first I'll swear in the petitioner, Ms. Herbert, and then I'll swear in, Mr. Fortin. And then following that, I'll make a determination as to whether or not, an order should be entered. You folks still live in the same building?
Yeah, I've been living there for like since the late 90s. I just had like, it's been a
So
year.
hang on, ma'am. Remember that part about me swearing you in?
Oh, sorry, my
Could
bad.
you raise your right hand, please?
Uh-huh.
Or your right hand. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes,
You can put your hand down. So you're asking for an order against Mr. Fortin. You said you've been living there since the 90s.
yeah,
And then, but why don't you, I mean, I reviewed your petition. The long and the short of it is,
Yeah.
it looks like you're contending that he's, for lack of a better set of terms, dumping paint on your car,
yeah,
basically?
he's been doing
All right.
that since March.
So go ahead. I'll hear from you.
Yeah, it's been, he's been doing that since March, because he sent me a little warning, like on Saturday, March 8th, I believe. And then I guess he started putting that yellow stuff on my car, but I didn't put two and two together until a couple of weeks later. But he's been egg, like, I guess it's eggs or something, that yellow stuff. He's been egging my car since March. He's been doing it like frequently until I officially saw him on Sunday, June 8th in the morning.
And then I see there's a police report.
Yeah.
Tell me about what happened there.
The police, police report, I had called 911 when I saw him doing it, right?
Mm-hmm.
And then I got my parents, went downstairs to see exactly what he put on my car was the yellow stuff. And I waited downstairs for the police. And the police arrived and they asked me what happened, right?
Mm-hmm.
And then I told them that the defendant was in the apartment right now. And so they went to talk to him to get
his. You live right above him?
Yeah, I live right above him, unfortunately.
And then, all right, is it stopped at all?
Well, it stopped.
After that time when the police came, has it happened after the police?
No, it hasn't happened after the police. Yeah. Because in the police, can I speak, Your Honor?
Yeah.
Because in the police report, right, the police said they didn't mention who got the car painted on. He started talking about me.
No, I reviewed the police report, so I know what's in there, man.
Yeah, okay.
Mr. Fortin, could you raise your right hand?
Yes, Your Honor.
The information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. What's your position on all of this?
Okay, I deny all allegations, and in my defense, the plaintiff herself has been harassing me for several months. She pounds on the floor all throughout the night, preventing me sleep. I've tried to put an anti-harassment order on her. However, the judge denied it due to lack of evidence. And I did get previously, I received a text from the apartment manager. Apartment manager says that the vehicles were getting eggs put on them, and that was all.
How long have you lived there?
I've been here for 7 years.
I mean, was there ever a point when you folks got along, or did you never get along?
No, oddly enough, it was very quiet when they first moved in until one of the other tenants, the other noisy tenant, moved out, and then she starts in with the noise. And it's been like that for 7 years, Your Honor. It's ridiculous. The apartment manager will not do anything about it. I've talked to law enforcement many times about it, and no help from nobody. And it's just unbelievable.
Go ahead, ma'am. What's your response to
my response is, right, I was living in I-5 with some nice, it was nice where I was living. Only reason they moved me because they had to remodel because I was living there so long. So that's how I ended up above him.
I see. How long have you lived up above him? He says 7 years. Has it been?
No, I was living in I-5 since like 1998, 1999.
Right.
So, and then it's probably been a year, almost 2 years that I've been living above him in October. Or
What about he says you're thumping around?
The only thing I do is walk around and sometimes I walk around after quiet hours because the quiet hours is from 10 p.m. to 7 a.m., right? Apparently in Tumwater. So I walk around to either go use the bathroom or get some water or something.
But you're not like marching, stomping, or
no.
Mr. Fortin?
Yes. What she's saying is a lie. She's cruelly pounding on the floor all throughout the night, and then claiming to be a victim.
What do you mean, all throughout?
Yes.
I mean, like all night long?
About every 30 minutes, 40 minutes, an hour, there's huge booms. And it is doesn't take very much to determine the difference between somebody walking around and some huge boom all throughout the night.
Go ahead, ma'am.
But Your Honor, that's an old apartment complex. It's been around for years. The floors are very weak.
Which one is it? I don't.
It's Falls Point Apartments.
So the thing that's on your car there, ma'am, is that, is it just eggs? I mean, just eggs, but I mean, it's annoying. But I mean,
Yeah.
at first, I wasn't sure whether it was paint or not.
Yeah.
If it's paint, then that's,
Yeah.
that's a damage to a car, which
Yeah.
would cost money to get it
Yeah.
fixed. If it's eggs, might
Yeah.
not necessarily be damage to the car, but it's still annoying.
Yeah.
So what is it? Is it
Well,
eggs?
I've been wiping them off, writing police reports. I really haven't smelled it or tested out or got it to figure out what it was. But it's not paint though, because it comes off easily.
Okay. And it's not, I mean, is there eggshells there or you don't know what it is?
No, there's no eggshells there.
All right. Give me a minute. Anything further there, Mr. Fortin?
Nothing further, Your Honor.
All right, give me a minute here. You work, ma'am?
Oh, yes.
What do you do?
I'm a CNA at St. Joseph's Medical Center. And then I do per diem at Lacey Post Acute.
Okay. So you hold down 2 jobs?
Yeah.
Has anybody ever talked to you about noise?
No, I haven't since only problem is him because I called him, I went down, what was it, Friday to ask the management, has anybody reported anything since I've been living there? They said no. This is the first time somebody complained about me.
And did you take pictures of this car?
The pictures I have my own, and plus I have basically the same pictures you probably seen in the report.
So here's where I'm at there, Mr. Fortin, and Ms. Herbert. So I reviewed the police report. I spent some time looking at the police report. You know, these cases are decided by a preponderance of the evidence. Is it more likely than not an order is necessary? Basically, based on what's in the police report, including, you know, Ms. Herbert indicates that she observed this firsthand. There's also some supporting evidence from the officer. Apparently, you viewed your video, Mr. Fortin. So I am going to find that that's a pattern of harassment. I should have done this earlier. Harassment is a knowing and willful course of conduct to vex, annoy, or harass someone else, which serves no lawful purpose. I am finding that dumping a yellow substance on her car constitutes that. And so I'm going to enter an order, which is basically is, you know, you're not to contact her in any way. You're not, you know, there's no distance restriction or anything like that. You just folks aren't to communicate. And I would interpret any sort of future occurrence to her car as contact, which would be a violation of the order. Looks to me like, I don't know whether you were aware of this or not there, Mr. Fortin, but you got charged and you have a court date coming up on the criminal calendar. Were you aware of that?
Yes, Your Honor.
Okay, you need to be back on July 15th. And so this order is going to be in place for 1 year. And that's what's going to happen here today, ma'am.
Thank you, Judge.
I don't feel it. And again, Mr. Fortin, I'll be frank with you. I don't, you know, Ms. Herbert, you know, comes before me. She's working 2 jobs. Oh, is she gone?
Yeah.
Okay, well, I was gonna say you probably spend more time sleeping than anything else in your apartment. Anyway.
Do I gotta show, sorry.
That,
Do I gotta, since he has the court date for July 15th, do I gotta show up?
nope, nope.
Okay.
You don't, they'll contact you.
Okay, good.
So since he left, okay, ma'am, we're gonna make a copy of this for you here in just a second. He'll contact you. There's not a distance restriction, like don't come within 1,000 feet.
Too bad that can't be a no, like a noise, no contact either.
Well, there's nothing I can do about that, ma'am. And since he's not here, I don't want to make any further rulings.
Okay.
Wait for a minute, ma'am. We'll give you a copy of that, and then you're free to go.
Okay.
Good morning. Are you Xavier Garner?
Yes, ma'am.
And Mr. Garner has 4 cases, and 230957, harassment by a person in a correctional facility, 242322, aggravated, 242323, and 2324. And Mr. Matuska, what is the announcement?
Your Honor, I've been able to collect most of the discovery. Still trying to get some of the digital media. I do expect this case to be placed on the trial docket. I just need to get the digital media.
Okay.
I've talked to Mr. Nichols about that, and that should be shortly.
We did speak, Your Honor, but I've been out the last few days, so I wasn't able to get that resolved for him this time around.
Okay.
I think it shouldn't be hard to get it for him, make sure he has everything.
Okay, so I'll do one more reset, and this will be the last reset. Y'all make sure you visit about all of that. Mr. Garner, what I have here is a pile of jail incident reports. So I want you to make sure you know that I know everything you're doing in court. And if this goes to trial, a jury will know everything that you're doing in our jail. Do you understand that?
Yes, ma'am.
You're fighting, you are talking back in an extremely ugly way to the correctional officers who are just there trying to do their job. That's their job. They're just going to work every day. They don't need to hear this crap from you every day. Every single day you're talking back, you're calling names, you're not following the rules. You want to do it your way. When you're in jail, you don't get to do it your way. And if you do continue to do it your way, you're going to end up with another harassment of a public servant in a correctional facility. You're going to end up with more time if you get found guilty, because a jury's going to be mad because they're going to hear about all these things. So I want you to stop, and I want you to understand, and I've been telling every one of you, how old are you?
22.
22 years old. It's all of you young kids out there acting like absolute heathens. So if you want your life to get better, you tell the rest of them, hey, I'm not going to get in trouble anymore. Y'all do what you're going to do. But running up on people, stealing their food, calling names, it's only going to get you in more trouble. All right?
Yes, ma'am.
Go back with the bailiff. Good morning. Are you Jacqueline Young?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not gonna let you guys negotiate. That, I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 21-37857.
Your Honor, it's a second amended, just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13, 13 being the offense he's already pled to.
Okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh, it
count
was-
20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending.
The failure ID is still pending next door, Judge.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else that like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that? It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different, but I'm not gonna do that. All right, so we are back on the record in cause number 21-37857. And again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the
new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank you.
All right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not, I mean, it's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Good morning, ma'am. You're Veronica Randall. And Miss Randall has two cases, 250246 and 0247. Both are theft of property with previous convictions. And Mr. Vasquez, what is the announcement?
Judge, we asked for a short reset. I need to, Ms. Martinez made a reasonable offer, but I need to do some research in Ms. Randall's case.
All right, and
Judge, I think this is Mr. Vasquez's first setting on this. Previous
I
setting,
see
you
that.
asked me to kind of map the indictment. It's so many priors that it almost makes you cross-eyed.
yes,
I think we just have a friendly disagreement on what level it is. The offer as I have made for 4 years, TDC would be valid if it was either a third or a second. Mr. Vasquez's position is that it's a state jail. I will go back and look at it again. That is not my position. I will have another set of eyes on it because, like I said, it's so much it gets tangled up. But regardless, I think it's at the very least a third.
Thank you, Ms. Martinez, for your explanation. I'm sure I'll be in agreement, Your Honor. I'm just not certain right now.
okay.
And I'm supposed to know these things.
That's okay. So what I'm going to do is one more reset. This will be the last one. Y'all take a look at all of it and all the priors and get that worked out. And then we'll get an announcement at the next court date. Either it's going to get worked out with the plea or it's going to go in the trial docket. So, Ms. Randall, I want you to know that I receive jail incident reports. So everything that happens out at the jail, I get a report of. The assistant district attorney gets it. Your attorney gets it. If you want me to accept any plea agreement later, this behavior needs to change. If you go in front of a jury, they're going to see these things. So you've got to follow the rules. If you want any benefit from any of us or a jury, you've got to show us that you can follow the rules and not continue what you've been doing in that jail. Do you understand? You're too old for this behavior, right? A lot of times I'm having this conversation with my 18, 19, 20, 21-year-old boys. That's who's acting up in the jail, not you. All right. So stop this because everybody's going to know what you're doing. All right. Okay. We'll see you at the next court date. You can go back with the bailiff. Brianna Clannon. Good morning. Are you Brianna Clannon? Answer out loud so I can hear you. How old are you? You're 20. Next time, wear something more appropriate to court. Okay? Do you agree that that's probably not something appropriate to wear to felony court?
Yeah.
I tested you this morning. You gonna have anything in your system?
No.
Have a seat in the jury box. We're gonna get you drug tested.
Thank you. All right, I'm ready on Kelly Smith. I need Mr. Shelton to take his hands down off the bench.
Oh, yes.
All right, this is case number 254495101, the people versus Kelly Jane Smith. Defendant is charged with stalking. Today is the day set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Dillon, about the people.
For the record, Your Honor, Janice Stevens, I'm appearing on behalf of Ms. Kelly Smith. Ms. Smith, please say your first, middle, and last name.
Kelly Jane Smith. Did the officer tell you how Ms. Smith put her hand up to me?
She did, Your Honor. Ms. Smith, there was a little bit of a mix-up. We were.
That I was the judge sitting on the bench with these pearls and this robe on with that seal above my head. It was a mix-up that somebody gonna put their hand up to me. That's the mix-up.
Understanding that if Ms. Smith is gonna come into the courtroom, she should just come in, have a seat, wait to be acknowledged, and I think she understands that.
What's the mix-up about me saying?
Trying to get your attention and shouldn't have done that.
You said this trying to get my attention? Let me say something to you. I grew up on the east side of Detroit, 6115 Senator. Putting up your hand like this when someone is addressing you, that's saying, that's dismissing. That's saying, stop talking to me. That's not saying get your attention. Cause how could, you not trying to get my attention, cause I'm saying officer, have her step out, cause I'm in a jury trial.
Okay.
And my officer is in here tending to me and the jury, and I'm saying, you have her step out. And then she did me like this.
Oh, I thought it was okay, well,
She did me like this. She said,
all right,
that's what she did me.
not gonna happen again.
Okay.
Not gonna happen again. I've had Ms. Smith and I have had a good working relationship.
Oh, well, keep having that good work relationship. And what's today? 24. And that shirt. Ms. Keisha, when did I cut you off?
I'm not sure, but we're gonna just ask that the matter, well, really, I'm asking for an adjourned final pretrial conference for resolution, Your Honor, but if not, we can ask for a trial date with a jury trial date with a final pretrial date.
How long for the resolution?
Until after the 2nd of July, Your Honor.
So if I gave you, how many do I have on July 7th? Is the bench trial for Montgomery, is that a resolution? Are you all planning to go? You don't know.
Shannon Montgomery, I believe we have an offer for pretrial resolution money. I don't know if you get familiar with it, but that one sounds not that highly likely.
If I give her July 7th, is that good?
Yes.
Okay, so let's do a final pretrial conference, I'll adjourn the final pretrial conference to July 7th, and then if no resolution at that time, then I'll give it a try. That's at 9. The resolution requires in person?
It is not, Your Honor.
Okay, so 9 o'clock, she come in person or on Zoom. All right, anything further?
Nothing by the people, Your Honor.
All right, I'm ready on.
Okay, Ms. Dyson, this is 25P 141484. This is a citation that was issued alleging that you were parking on private property without the consent of the owner back on the 24th day of May, about 8:30 in the evening. Are you here to admit or to deny responsibility, or to admit responsibility with an explanation?
Well, actually, probably to object and then I guess to give an explanation.
We'll call that a denial then. If you'd raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
Okay, the officer will testify first, please.
So good afternoon, Your Honor. On Saturday, May 24th at approximately 8:30 p.m. in the area of Main Street and 2nd Street, I observed a white Jeep parked in the Citizens Bank lot at 200 South Main. This lot is private property for the bank customers, and after hours is prohibited parking. The bank hours are Monday through Friday, 9 a.m. to 4 p.m. and Saturdays from 9 a.m. to 12. And there are 2 spots assigned in the lot for ATM customers only. And this particular Jeep was not parked in the ATM spots.
Thank you. Ms. Dyson?
Okay, I actually have a medical condition that I've been receiving treatment for several months. I have, I guess it's called coccydynia, tailbone pain. And this particular day, I had to go downtown to take my daughter. I was stuck in traffic for over 2 hours. So I actually went to that bank to go to the ATM. I was not aware that there were specific parking spots for that specifically. I did send in documentation regarding my medical condition. I emailed those to the court this morning. I don't know if you've received them. And then I also attached the ATM receipt proving that when I got out, I did need to walk around for a little bit because I was in pain from sitting. So I did not go immediately to that ATM. I do admit that. But I walked around for maybe 10, 15 minutes and then I used the ATM and I went home. So I did see that ticket after the time that I used the ATM and returned to my vehicle.
Okay, the city enforces this because the bank, the owner of the private property, wants it to be enforced. They have provided signage that makes it very clear that there are 2 spaces for the ATM machine. And in this case, the ATM machine was used 11 minutes after the ticket. How long the car had been there when you got the ticket, I have no idea. But the bottom line is that your medical condition had nothing to do with where you parked. And there's all kinds of parking in downtown Royal Oak. There's on-street parking. There's the parking garages. There's all kinds of spots. So this, and the other factor is that this is very clearly marked as not being public parking.
I only saw the signs that said not for customer parking only, which I mean, I considered that since I was using the ATM, I thought that made me a customer at that time. I did not see any specific parking spots that said ATM. And if you say they were there, I believe you, but I'm saying I did not see them.
And that doesn't, civil infractions have no intent to do evil. Crimes have an intent to do evil as an element, or else negligence that's so very gross that it's culpable. Civil infractions are mistakes. Sometimes, very often, not intentional mistakes. Just somebody can forget and drive faster than they should. Somebody can forget they can't make a turn. Then they make the prohibited turn. So there's no element that somebody looked at the sign and said, oh, I don't care, I'm going to do what I want anyway. That's just not the way civil infractions are. There are no points for parking violations, but your vehicle was there. It was ticketed. And when it was ticketed, it was in violation of the signage. So I couldn't do anything other than find you responsible. And the fine is $20, which needs to be paid online or by mail, or at the courthouse counter if you prefer.
It is $20. That's not what's stated on the ticket, but
What's stated on the ticket?
I believe it said $50.
$50 for private property, correct?
Yes. Yeah, you're right. $50, $20 is the overtime. 50 is the private property or prohibited or improper. So this is 50. You are correct. And you can do that online or by mail, whichever one works for you.
Okay.
Thank you.
Yep.
So that was a lot of little short cases that I saw today. I didn't see anything really great that was longer. There was one that I really kind of wanted to do. The subject wasn't very interesting, but the people were pretty funny. But somebody else did it before I got a chance to, so I lost that one. But I have posted my email address for the channel. It is in the description. And if you happen to have or know of somebody that has the May 5th trial from Conneaut, Ohio, I have this, that's the first half. I have the second half and the decision, but I don't have that first half of the trial, and I'd really like to show it to you guys if I can get it. If not, I'll show you the second half and the decision, because the decision is actually the best part. But if you do, send it to me at that email address, or if you see anything else that you think, hey, you should do this, and grab it quick, let me know. Send it to that email address. I would really appreciate it. Thank you guys so much for watching, and I'll see you another time. I shouldn't say see you next time. That spells out a bad word. I didn't realize that. It just dawned on me a couple days ago. I will see you another time. So thank you for watching. I'll see you another time.